All right, today we're diving into a story of two Americas, two U.S. jurisdictions that could not be more different in how they deal with conflict. On one side, you have a place where the legal system is deeply woven from ancient traditions. And on the other, a place that is, for all intents and purposes, a complete legal blank slate. This is a tale of two very different legal worlds. And this table just lays it all out, plain and simple. I mean, look at this contrast. You've got Hawaii, a state with a complex, hybrid legal system that actually has a constitutional mandate to recognize customary law. It's got mediation centers, the whole shebang. And then you've got Palmyra Atoll, an uninhabited territory run by the U.S. Fish and Wildlife Service. The law there is just federal law. There's zero recognition of customs because, well, there's no local society to have any customs. The difference is just night and day. So that's what we're exploring here, this huge divide. On one hand, you've got a state with a living, breathing cultural history that actively shapes its laws every single day. On the other, you have an uninhabited territory that's really just an administrative box on a map. It's a perfect natural experiment, you know? It shows us what happens when culture and law are deeply intertwined versus when there's no culture at all.
And here's the heart of it. Hawaii's legal landscape is this rich tapestry, woven from native Hawaiian, Chinese, and Japanese influences. It creates this culture that's all about consensus building, about finding a way to get along. Palmyra Atoll, though, it's a true tabula rasa, a blank slate. No local community means no local traditions. It's a place that's managed entirely from the outside.
So how does all this cultural depth actually play out in Hawaii's approach to justice? Well, to get it, you have to understand a totally different worldview. In traditional Hawaiian thinking, a conflict isn't some legal problem you need to solve. It's more like a spiritual illness that needs to be healed. It's about making things whole again, not about picking a winner. And right at the very heart of this philosophy is the concept of pono. Pono is so much more than just a word. It's an entire ethical foundation. It means rightness, harmony, and balance in absolutely everything: your thoughts, your actions, your relationships. Achieving pono is the ultimate goal, and any unresolved conflict is seen as this major disruption to that balance, something that can make you physically and spiritually sick. Okay, so if pono is the goal, then ho'oponopono is the journey to get there. It literally means to make right. And it's not about finding a winner and a loser. It's this really sophisticated system of restorative justice that's all about digging up the real root cause of a fight, getting rid of it, and bringing harmony back to the family and the community. And this isn't some informal chat, you know? Ho'oponopono is a super methodical, two-phase process. First up is the preparation phase. A facilitator called a haku works with each person one-on-one. The whole point is deep self-reflection to find your oia'il, your inner truth, your personal responsibility in the whole mess. It's only after everyone has done that work that the session phase can even begin. And in that session, all communication is filtered through the haku to make sure things don't blow up and to guide everyone toward forgiveness and ultimately back to harmony.
Now, you might be thinking, okay, this all sounds like a fascinating cultural practice, but it's separate from the formal legal system, right? Wrong. In Hawaii, that's not the case at all. This ancient philosophy isn't just some historical artifact. It's formally embedded and legally protected by modern state law. And get this statute right here is the perfect example. It says that the Western common law tradition, the one from England, is the law of the state except where it's inconsistent with established Hawaiian usage. This isn't just a polite nod to local culture. This is the law literally saying that in a conflict between Western common law and indigenous custom, the custom can win. That is incredibly rare in the United States. And it's not just some old statute. This idea is baked right into the state's highest legal document, the Constitution. Article 12 flat out guarantees that all rights traditionally exercised for cultural, religious, or subsistence reasons are protected by the state. So yeah, tradition has real legal teeth here. The courts have even come up with practical tools to make this happen. It's called the Kapapaka IA framework, and you can think of it like a three-part test that forces state agencies to hit pause. Before they can approve a project, they have to specifically identify cultural resources, figure out how the project might mess with traditional rights, and then spell out exactly what they're going to do to protect those rights. It makes cultural impact a mandatory part of the legal process. So let's put these two systems right next to each other. How does the traditional Hawaiian approach of ho'oponopono really stack up against the formal, Western-style mediation that's also used all over Hawaii? You're about to see that their goals, the roles people play, the whole process, it's all fundamentally different. I mean, just look at the difference here. With Ho'oponopono, the goal is all about internal healing and fixing relationships. The haku acts as a moral guide. But in Western mediation, the goal is just to get a voluntary settlement. The mediator is a neutral referee who just manages the process. One is about restoring the health of the community. The other is about letting individuals make their own deals. And this really gets to the very different ways they think about truth. Western mediation is all about establishing the objective facts. What happened, who did what, the evidence. Ho'oponopono, on the other hand, is searching for oiaio, which is more like the substance or the inner truth. It's about looking inward, cutting through all the blame and emotion, and taking full, honest responsibility for your part in the conflict. It's a totally different type of accountability. So why does any of this matter outside of Hawaii? Because this hybrid legal world offers this incredible, living blueprint. It shows how a modern legal system can be made more effective, more human, by integrating traditional wisdom. That's a path that a place like Palmyra Atoll, where the only tool is federal law, could never even go down because there's no community there to heal in the first place. And, there are some really practical lessons we can pull from this. For any place dealing with cultural diversity, this points to a need for specialized training and new hybrid models. It shows how powerful it can be to have bicultural teams working together. But maybe the most important lesson is a fundamental shift in the goal, moving away from just getting a transactional settlement and moving towards building relationships that can actually last. At the end of the day, the Hawaiian model really challenges our whole idea of justice. It asks us to move beyond a purely transactional view, where you just sign a deal and walk away, and move towards a relational one, where the health of our relationships and our community is the ultimate prize. Which really leaves us with one last question to think about. In our own lives and in our own legal systems, what if justice was less about the fight to prove who is right and more about the collaborative healing process of making things right? It's a question Hawaii can help us answer, but a question that a legal blank slate can't even begin to ask.